Thanks to a recently granted FOIA request, we've discovered that the SEC was very much a participant with FINRA in deciding the fate of MMTLP investors. The video, MMTLP 12-12-22, which is just under 15 minutes long, does a fairly decent job of analyzing the meeting participants from the SEC and FINRA on that date. With the help of artificial intelligence, it examines their titles to determine what their presence at the MMTLP meeting likely meant. But the video doesn't just focus on the fact that a meeting occurred. It also incorporates facts we've learned in the 2.5 years since the U3 halt. Facts that FINRA and the SEC likely knew but kept hidden from the investors they claim to protect. At just under 15 minutes, it really is worth the watch. Thinking about that meeting is a reminder that many questions still linger about how FINRA chose to conduct itself after the U3 halt of MMTLP. And with the latest advancements in Google Gemini and ChatGPT 5, I decided to ask both models some simple questions to see how they'd respond. The responses were consistent, though ChatGPT 5 offered to elaborate in a variety of ways. These responses will be in another video. And while I don't encourage anyone to blindly rely on AI, it's a powerful tool now available to us mostly for free, backed by billions of dollars in investment. The regulators likely didn't anticipate retail investors having access to these tools back in December 2022. But since we do, it's worth exploring the results, so long as we do so responsibly. Please, if you know for a fact that any of the information is wrong, point it out and I'll gladly take the videos down and wait for the technology to catch up. In Google Gemini, I asked the following. If FINRA halted trading in an OTC security, would it be difficult to determine which specific brokerages allowed trading of that security? Would it take a long time if it was approximately 105 brokers? Would FINRA know how to contact each broker's corporate actions department? This was the response from Google Gemini. Based on standard regulatory procedures and technology, the answers to your questions are a definitive no and yes. No, it would not be difficult at all. FINRA has access to the Trade Reporting Facility, TRF, and the OTC Reporting Facility, ORF. All brokerages that are FINRA members are required to report every trade they execute in an OTC security to these facilities. Since FINRA operates and collects this data, they have a complete electronic record of every firm that has traded a specific security. Identifying which firms allowed trading is a routine database query that would take their systems seconds to complete. No? It would not take a long time. Whether the number is 5, 105, or 10,500, a modern regulatory surveillance system can identify all firms that traded a particular security almost instantaneously. The data is structured, electronic, and readily searchable. The time it takes is not dependent on the number of firms, but on the speed of the database query. Yes, FINRA would know how to contact each broker's corporate actions department. As a condition of their membership, all FINRA member firms are required to provide and maintain accurate contact information for key departments, including compliance, legal operations, corporate actions. This information is kept in a centralized database specifically for the purpose of regulatory communication. When a trading halt or corporate action is initiated, FINRA uses these official contact channels to send out regulatory notices and coordinate with member firms. I then asked, okay, let's say FINRA needed to contact 105 brokers while trading was U3 halted, just to find out if each brokerage intended to allow the opening of new positions after a particular date. And if their answer was yes, FINRA needed to correct them by informing them that it wasn't allowed because it would cause an issue related to settlement and clearance. Would this be a burdensome or out-of-the-ordinary measure to take, especially given that it's FINRA's role to facilitate orderly settlement? This was the response. No, this would not be a burdensome or out-of-the-ordinary measure to take for FINRA. In fact, it is exactly the type of action they are expected to perform when a U3 halt is in effect. Contacting 105 brokers is a routine communication task for FINRA. They have centralized data. As previously established, FINRA's systems can instantly identify all firms that traded the security. Official channels. They have official, up-to-date contact information for each firm's relevant departments. Dedicated staff. FINRA has staff dedicated to market regulation and corporate actions who are trained to perform these communications efficiently. The logistical effort required to make these contacts is well within FINRA's standard operational capacity. The U3 Halt itself is an extraordinary event, but the regulatory follow-up is not. A U3 Halt is initiated precisely because there is an extraordinary event that causes significant uncertainty in the settlement and clearance process. To resolve that uncertainty, FINRA must communicate with the market and its member firms. Correcting a misunderstanding about the opening of new positions, an issue that could directly impact the settlement process, is the most logical and necessary action for FINRA to take to fulfill its mandate of facilitating orderly settlement. Taking this measure would be a core function of FINRA's role. Not taking it would be considered a failure of its duty. Finally, I asked this. Okay, but because of the halt, the corporate action timing was disrupted. And perhaps there also needs to be clarity about the timing of closing short positions before cancellation of the shares. What could FINRA do in this situation? Would the best option be to not address open short positions? Some added information. This is a one-for-one exchange that would result in the original tradable security being exchanged for a non-tradable, non-DTC eligible security for which there will be no market to later address closing short positions in an open market. This was the response. Given this complex and highly unusual situation, the best option would absolutely not be to ignore open short positions. Doing so would be a profound dereliction of FINRA's duty and would lead to a chaotic and disorderly market. Here's what FINRA could and should do to facilitate a fair and orderly settlement process. FINRA's primary objective would be to correct the disruption caused by the halt and create a new, clear path to settlement for all parties. The steps would include: extend the deadline. FINRA would work with the issuer to officially extend the deadline for the corporate action. The halt disrupted the market and created a new state of uncertainty, so a new timeline is required. Provide a clear, closing-only window. FINRA would issue a new, highly visible regulatory notice. This notice would inform all member firms and the public that a new specific window of time, for example, 2 days, 1 week, has been designated for the express purpose of allowing all open positions to be closed. This would be a closing-only period to prevent any new market activity that could exacerbate the problem. Coordinate with market participants. FINRA would use its official channels to contact the relevant departments at all 105 brokers, ensuring they understand the new timeline and the necessity of this closing window. Clarify settlement rules. The regulatory notice would explicitly state the rules for settlement and delivery during this window. This is especially critical for short positions, as it would provide a clear path for them to cover their shares before the final cancellation. Ensure fair communication. FINRA would also ensure that the issuer's new corporate action language and dates are communicated in a fair and transparent manner to all investors, leaving no room for ambiguity about the final date for the conversion. Why ignoring open short positions is not an option. Creates a disorderly market. A market where an entire category of open positions cannot be closed is, by definition, disorderly. It would lead to countless disputes, legal battles, and a complete breakdown of the settlement process. Punishes lawful activity. Short selling is a legal and integral part of the financial markets. Ignoring these positions would effectively punish legal market participants, which is a direct violation of FINRA's duty to protect all investors. Violates regulatory principle. The purpose of the U3 halt was to address an issue of settlement and clearance uncertainty. To then proceed with an action that guarantees a settlement and clearance failure for a significant portion of the market is illogical and would be a fundamental regulatory failure. In this scenario, FINRA's role is not to pick winners or losers, but to ensure that the rules of the road are clear and fair for every market participant, and that the corporate action, however disruptive, is ultimately processed in an orderly manner. So what are your thoughts? Does Google Gemini sound like it knows the correct procedure that FINRA should have followed? And now that we know that the SEC and FINRA met on the day before FINRA says they deleted the trading symbol, why didn't the SEC insist that FINRA implement the procedures mentioned by Gemini? Stay tuned for the video with the ChatGPT 5 responses.